Good afternoon. Not legal advice. Like, subscribe, share, comment, and if you don't, I'm going to send you a bill. So please do so. Wanted to do a video today. I saw that Rudy Giuliani had a judgment entered in against him for defamation, and I think it would be confusing unless I explained to you how it got to that point in time. But I just wanted to inform you about this great, interesting restaurant experience I had at this new restaurant called Karma. It's really super interesting because they don't have a menu, but you get what you deserve. Anyway, moving on to Mr. Rudy. So this involves the trial in Georgia where he's accused of defaming a couple of election workers, accusing them of, I think, criminal conduct and maybe treason or things like that. So you have a case, complaints filed and a response, etc. And then we've heard about discovery and understand there's a difference between discovery in a civil case where you're seeking money damages or the like and a criminal case. Completely different ways discovery occurred. There's not depositions in a criminal case. There's more exchanges of documents, and you have private investigators, etc. But in civil cases, there's more of an exchange between the two sides. So the Giuliani case that I'm referring to, and I'm not going to get into the merits, but I'm talking about the procedure and how a judgment came about. But anyway, the case was about defamation and some other claims. There may have been other parties involved anyway, but I don't know. I'm not sure. But what happened was, in the case, there was discovery propounded. So the plaintiffs, the parties that were bringing the lawsuit, sent out discovery requests to the other side, and they were requests for the production of documents. So in California, the way it would work is I'd generate a document. I'd have categories of documents I'd wanted that pertained to the lawsuit. I would send it to the other side. They'd have to respond in writing and also deliver responsive documents. Now, typically what happens is that doesn't happen directly. There may be delays. There may be agreements between counsel. But ultimately, there comes a point where you have to respond. So in this particular case that we're talking about today, I guess the stumbling point were particular financial documents that were being requested. So ultimately, Giuliani did not produce the financial documents. What he did was and the reason he probably did this, and I'm just speculating, again, not legal advice, but he has a bunch of cases he's facing now, some of them civil, some criminal. Obviously, civil is about money damages, and I think he's going to portray himself, and it may be factual, that he's broke at some point in time because he's paid lots in legal fees. It's probably tough for him to earn money directly, and for all intents and purposes, he may be judgment proof. But in terms of the criminal, to the extent he's found to have engaged in criminal misconduct, obviously that could result in jail time. So, not that I was obviously involved in his defense, but if I was defending him, I would be more concerned about the criminal side. So, apparently what happened in the civil case is they asked for certain documents. Eventually they didn't produce them. The plaintiffs, the parties seeking the documents, filed a motion with the court, asking the court for an order to order Giuliani and his counsel to produce the documents, and then imposed monetary sanctions against Giuliani for the plaintiffs having to chase this down, etc. It was a sizable amount, by the way, also, about $90,000 in legal fees. So the order is produced. It says Giuliani produced these documents. He refuses. They file a second motion to compel. There's quite a bit of time that's passing by between each motion and the court hearing, or if there is a hearing. But you're probably talking about 60 days, maybe 90 days each time. So there's an order. He doesn't obey. There's a second motion, and he doesn't obey again. So they file a third motion. In the third motion, they ask for an entry of a default judgment, which means that as opposed to the necessity of having to go to trial, the court could enter a judgment, not in terms of a monetary amount, but a judgment against Giuliani, and that would preclude Giuliani from contesting liability. Now, what's interesting here is in response to the court ordering the documents produced and in response to all the motions, Giuliani later took the position that he was not going to oppose the recitation of the facts in the complaint, nor he wasn't going to oppose punitive damages or anything like that. So, in effect, he conceded liability in court filings. And the reason why that's significant is because this type of defamation, so he accused of these workers of criminal misconduct or worse, and that in most states is considered to be defamatory per se, which means you don't have to prove up any loss or damages. It's just considered to be defamatory if you make those statements. So he didn't contest that in the court hearings. The reason why he didn't contest it, he was trying, and I think he indicates this in his documents, he didn't want to disclose that particular financial information. You can guess why he did not. I'm not going to speculate. So the court ordered him twice to produce. He didn't. On the third time, they entered a default judgment. So there's a judgment against him. But now there will be a further trial on damages. So we know that so far the court has awarded approximately a judgment per the two motions for legal fees to plaintiffs in the total amount of approximately $140,000. That's just based upon Giuliani's noncompliance and need to file motions, etc. That's what the court awarded plaintiffs in response. Whether it's collectible or not, is another thing. On the third try, they just kicked him out. And his attempt, again, because he made it in the filings with the court, was to accept responsibility so he wouldn't have to disclose his financial records. Now, he also put some squirrely language in these stipulations suggesting that he might have the ability to contest these assertions in other matters, and it only applied to this case. But he certainly did indicate that he would not contest the facts that this was defamatory per se on its face, wouldn't contest punitive damages, and the payment of legal fees. So, based on that, the court ignored that and went to the document side and said, you haven't responded to the two orders, you haven't responded to the documents, and in light of that, in light of the ability to sanction parties, I'm going to enter default judgment against you. So, in effect, she used the failure to give discovery, as opposed to Giuliani's admissions that he wasn't contesting the facts. Interesting. I think she didn't use both, but she used one. So now we come to the point, she'll set a trial, which she just did. It'll be for damages. It will be exclusive of those attorney's fees, but in a defamation action, and there's some other claims, but basically you get damages for whatever emotional distress you might suffer, for damage to your reputation, etc. Not an objective way of evaluating that. So it's basically what a jury might award. Could be large, could be in millions of dollars. And then on top of that, since again the court has found that the plaintiffs are entitled to punitive damages, there'll probably be some award of punitive damages related to the damages for emotional distress and other such. And if it's in the order of, let's say, $2 million, then you could have punitive damages, as much as $10 million or more. So combined, it could be a significant amount, which Giuliani probably can't pay and probably won't be able to pay. But it's no fun having a judgment hanging over your head. But he must, and his counsel must believe that it's better and safer not to disclose the documents than risk that disclosure. So, whereas people may have heard today that there was a judgment for defamation entered against Giuliani, and again, I'm not making it any determination because perhaps would have been justified anyway. But the way we got there was a lot different than one who didn't know the procedural specifics of litigation would think. And in this case, it was more non-compliance with discovery statutes. And I think 3 times and out is a fairer standard. The judge gave him enough time. And again, Giuliani and his counsel had different strategy in mind to protect, I think, Giuliani. But the bottom line is Giuliani is not going to have any money. At least it appears that way. And it was an interesting strategy not to disclose the information. He was also accused of having destroyed electronic documents. That was part of the accusation. And that also was fed into to the court papers. Anyway, that happened today. I think in Georgia, there'll be a further trial. It'll be interesting to see what the damage trial would be like. Usually punitive damages are correlated to wealth. So if you are Giuliani's counsel, you're going to say he's broke. But since they didn't produce the financial records, the court could enter some kind of instruction saying you can't believe what he said, basically, along those lines, because he hasn't produced the financial documents. It'll be interesting to see how it works out. But it was an interesting strategy to try to withhold the financial documents. He'll have an opportunity to produce them again at the next trial for damages, and we'll see how that turns out. Anyway, have a great day. Hope this is interesting. Be well. And again, subscribe, like, comment, or else you get a bill. Be well. Have a great day.